let's kick things off. Over the next decade or so, we're going to see this truly massive shift in wealth.
Yeah, huge. We're talking trillions of dollars
Mhm.
changing hands between generations globally.
It's a scale that's almost hard to wrap your head around. And it's going to reshape things for, well, millions of families, even those not yet born.
It really is. Some call it the Great Transition. And that's exactly why today we're diving deep into strategic wealth transfer and estate planning.
Right. And our goal here, based on the material you sent over.
It's to distill down the essential strategies. I mean, the things you really need to know to, well, secure your family's legacy, keep the tax bill as low as possible, and just avoid all those potential complications down the road.
It sounds straightforward, but the stakes are incredibly high, aren't they? People hear estate planning and maybe tune out thinking it's only for, billionaires.
That's a common misconception.
Mm.
But the sources we looked at really drive home that everyone benefits from a framework. Skipping this, it can be disastrous.
So what actually happens? What are the consequences if people just, well, don't plan?
Well, the difference isn't just about money, though it can certainly mean losing millions unnecessarily. It's also about family harmony, or the lack of it.
Ah, the family side.
Exactly. Poor planning, or no planning, leads to, well, our sources highlighted 4 main negative outcomes. We should probably walk through those.
Yeah, let's break them down. What's number one?
First, and maybe the most fundamental, is that assets often just don't reach the people you intended them for. Or maybe they do, but in a way that causes huge problems.
Okay, so your wishes don't get followed. What's next?
Second, the values, the principles you live by. They might just get ignored because there's no formal guidance for the next generation on how to handle things.
That's a big one. Third.
Third is the financial hit, unnecessary taxes. Wealth just gets eroded away because the right structures weren't in place. It's like leaving money on the table for the tax authorities.
Painful. And the fourth.
And fourth, this is the one that causes the deepest scars. Sparking family disputes. Seriously, a lack of planning can tear families apart for decades over inheritances.
Right. You hear those horror stories.
We do. History is full of them. So, proactive planning. It's the defense against all that. Lowers taxes, make sure your intentions are clear, and this is critical, helps you avoid that whole probate mess.
Okay, probate. You mentioned avoiding it. It sounds like something definitely to steer clear of. Can you explain what exactly probate is?
Sure. Probate is basically the state's default court process. If you die without a proper plan, the court supervises how your assets get distributed.
And that's bad. Because?
Well, a few reasons. It often takes a long time, months, sometimes years, can be expensive with legal fees and court costs eating into the estate. And crucially, it's usually public record. No privacy.
Public record. Ouch. So everyone can see the details.
Pretty much. So, yeah, if you value efficiency, low cost, and privacy, bypassing probate is a major goal.
Got it. So how do we do that? The sources mentioned 3 main ways, right? Actionable things people can do.
Yes, 3 primary routes to stay out of probate court. The first one is probably the simplest, something everyone should check, maybe even today.
Okay, what is it?
Beneficiary designations. You just directly name a beneficiary on your financial accounts. Think retirement accounts like IRAs or 401k, life insurance, bank accounts, investment accounts.
So you just fill out a form.
Essentially, yes.
Mhm.
When you pass away, the money in those accounts goes straight to the person you named. No probate needed for those specific assets. It's fast, private, efficient.
Simple enough. What's the second method? Often used for things like houses.
Right, that's joint ownership. Specifically, titling an asset as joint tenants with rights of survivorship, often abbreviated JTWROS.
JTWROS.
Okay, yeah. If you own, say, a house with someone else under that title, when one owner dies, the property automatically passes to the surviving owner. Again, bypasses probate for that asset.
Seems effective, but maybe less flexible.
That's the trade-off. You give up some individual control during your lifetime because you now co-own it fully.
Okay. And the third mechanism. This sounds like the big one, the real foundation for strategic planning.
That would be the trust. A trust is, it's like creating a separate legal container to hold your assets.
The container.
Yeah, a legal entity. You transfer assets into the trust, and then you write detailed instructions, the trust document, on how those assets should be managed and distributed. Since the trust owns the assets, not you personally at death, they generally stay out of probate.
Ah, so the ownership structure is the key.
Exactly. It provides immense control and privacy. It's really the cornerstone of modern estate planning.
That makes a lot of sense. So, if the trust is so central, let's talk about the whole toolkit. The sources mention several essential documents beyond just the trust itself. What else do people need?
Right, a trust handles the wealth management, but you need other pieces for a complete plan. It's about covering all the bases: personal, medical, financial.
So, within the trust itself, there are specific roles.
Yes, you, the creator, are often the initial trustee, managing things while you're alive. But crucially, you name a successor trustee. That's the person or institution that steps in to manage things after you're gone, or if you become unable to. Especially important for complex assets or, managing distributions over many years, even generations.
Got it. Successor trustee is key. What about documents for when you can't make decisions yourself?
Absolutely vital. First, you need a living will, sometimes called an advanced healthcare directive. This spells out your wishes regarding medical treatment if you become incapacitated and can't speak for yourself.
So, decisions about life support, things like that.
Exactly. It takes the burden off your family having to guess what you would have wanted. Second is the power of attorney.
Right, for financial matters.
Yes, you designate someone you trust, your agent, to handle your financial and legal affairs if you're unable to, maybe due to illness or an accident. It can be temporary or permanent.
Okay, living will for health, power of attorney for finances. Now, here's a common question. If I have this comprehensive trust handling my assets, why do I still need a traditional last will and testament? Doesn't the trust cover everything?
Great question, and it causes confusion. Yes, you still absolutely need a will, even with a fantastic trust.
Why's that?
Well, the will does a couple of things the trust can't. The big one is naming legal guardians for minor children. That has to be done in a will.
Okay, critical for parents. Anything else?
Yes. Most well-drafted plans use something called a pour-over will.
A pour-over will, what does that do?
Think of it as a safety net. Let's say you set up your trust perfectly, but then you buy a new brokerage account and forget to formally title it in the name of the trust before you pass away.
Okay, so an asset is left outside the trust by accident.
Exactly. The pour-over will basically says, hey, any assets I owned personally at my death that weren't already in my trust should be poured over into the trust.
So it catches anything that fell through the cracks.
Precisely. There might be a simplified probate just for that one asset, but the will ensures it ultimately ends up governed by your trust's rules, keeping your overall plan intact.
That really ties it all together. Okay, let's circle back to the trust itself. You called it the cornerstone, especially for multi-generational benefit. What are its sort of dual superpowers?
Superpowers. I like that. They really are powerful. The two big benefits are, I'd say, control and protection.
Let's start with control.
Okay, generational management. A trust isn't just about distributing everything at once. You can structure it to provide income or support over decades across multiple generations. The trustee manages this, following your specific instructions.
So you can guide things long after you're gone.
Yes, and sometimes there's another role involved here too, called a trust protector.
Wait, a trust protector, how's that different from the trustee?
Good question. It's a more advanced feature, often used in complex or long-term trusts. While the trustee handles the day-to-day management investments, distributions, accounting, the protector acts as an overseer.
An overseer, like quality control.
Kind of, yeah. They might have the power to, say, remove a trustee if they aren't following the trust mission, or veto certain decisions. They're there to ensure the original intent, the core values behind the trust, are upheld over the long haul.
That adds a serious layer of safeguarding the original vision. Fascinating. Okay, what's the second superpower?
Asset protection. This is huge. Assets held inside a properly structured trust are often shielded from the beneficiary's future potential problems.
Like what kind of problems?
Think lawsuits, creditors, maybe even a divorce settlement. If your heir faces one of these situations, the assets in the trust are generally protected because the heir doesn't own them outright. The trust does. It helps ensure the legacy actually lasts.
Okay, control and protection. Powerful indeed. Now, let's get practical and talk taxes. This is often a huge motivator. What are the key U.S. tax numbers people need to be aware of, say, looking ahead to 2025?
Right, the numbers are crucial for planning, especially for higher net worth families. Under current U.S. law, for 2025, the federal estate and gift tax exemption is around $14 million per individual.
$14 million. Wow.
Yeah, it's a significant amount. And for a married couple, that effectively doubles to about $28 million that can be transferred either during life as gifts or at death, completely free of federal estate tax. These are rounded figures, of course, and subject to change, but that's the ballpark.
That's a very generous exemption. But what if someone's estate is potentially larger, or they just want to be proactive about reducing its size over time? Are there other strategies?
Absolutely. Two very common and effective ones. First is using the annual gift exclusion.
That's the yearly amount you can give away.
Exactly. For 2025, it's expected to be $19,000 per recipient per year. So you can give $19,000 to as many people as you want each year without touching that big $14 million lifetime exemption and without filing a gift tax return.
And a couple could give double that per person.
Correct. A married couple could give $38,000 per recipient each year. If you have, say, 3 kids and 6 grandkids, that's 9 recipients, you could move over $340,000 out of your estate annually just using this method. It adds up fast.
Definitely. Well, what's the second strategy?
This one's often overlooked, making direct payments for certain expenses. Specifically, if you pay someone's medical bills or educational tuition directly to the institution, the hospital, the doctor, the university.
Not giving the money to the person first.
Critically important distinction, yes.
Yeah.
You pay the provider directly. Those payments are completely unlimited and don't count against either your annual exclusion or your lifetime exemption. It's a fantastic way to support family members while also managing your own taxable estate.
That's incredibly useful. Okay, so we've covered tools, taxes, but for families with significant wealth and complexity, managing all this, plus maybe integrating family values, it seems like it needs more than just occasional advice.
You're absolutely right. That's where we get into advanced planning, often involving what's called a family office.
Family offices. We hear that term. What exactly are they, and what do they do that standard financial planning doesn't?
Think of it as dedicated infrastructure for managing a family's wealth and, increasingly, its broader affairs. The focus shifts from just managing investments to managing the family and its legacy across generations.
The sources mention 2 main types.
Yeah, generally 2 models. The single-family office, or SFO, is tailor-made for one specific, usually very wealthy family. They employ their own dedicated team advisors, lawyers, accountants, maybe even concierge services.
An ultimate bespoke service.
Pretty much. Then you have the multifamily office, or MFO. This is where several families pool resources to share the costs and benefits of that sophisticated infrastructure and expertise. It makes those high-level services accessible to more families.
And their role goes beyond just money management.
Oh, absolutely. This is key. They get heavily involved in the softer side, the non-financial aspects crucial for a lasting legacy.
Like what?
Things like helping the family define its core values, its mission. Sometimes this is formalized into a document they call a family constitution.
A constitution for the family. That's fascinating.
It really is. It provides a guiding framework. The family office might organize family meetings, help educate the next generation about financial responsibility and philanthropy, facilitate difficult conversations about governance.
So they're not just drafting the trust documents.
No, they're helping ensure the principles embedded in those documents actually match the family's vision, and that those principles are understood and carried forward by future generations. It's holistic management.
This has been incredibly illuminating. Just to recap the key levers we've discussed. We have ways to bypass probate using beneficiary designations, joint ownership, and especially trusts.
Right. Then there's leveraging the tax rules, that big lifetime exemption, around $14 million per person, plus strategic annual gifting and direct payments for education or medical.
And finally, for complex situations, the potential role of single or multifamily offices to provide that truly comprehensive multi-generational management, blending finance with family value.
Exactly. And the underlying message through all of this, really, regardless of your current net worth, is the importance of taking action now. Don't wait. Review those beneficiary designations. Get the essential documents like wills and powers of attorney in place. Start the conversation.
Secure the financial future, but also, as you said, the emotional harmony of the family.
That's the goal. Peace of mind.
Okay, as we wrap up, let's leave our listeners with that provocative thought you mentioned, stemming from the family constitution idea.
Yeah, it's something to really mull over. We put so much focus, understandably, on the mechanics of transferring assets, the money, the property, the investments. And that's necessary, of course.
Right.
But the ultimate goal is a truly lasting legacy, one that really honors your life's work and values. Maybe the most vital document isn't actually the will or the trust that dictates the what and where of the money.
What is it then?
Perhaps it's the formal or even informal outline of the family's core values and principles, the guiding philosophy that will hopefully give the next generation the wisdom to use that wealth well. So the question to ponder is, if you were writing your family constitution today, even just for yourself, what principles would be non-negotiable? What values are you truly trying to pass on,